topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good morning, Houston. Welcome to another Ask the Expert show where for the last 16 years, we have brought you the finest experts in the field of legal, health, financial, and home improvement. Hey, this morning's show is such an important show. We have been airing community association shows throughout the country. One of them has been with us for 14 years. And what I found is not only are we educating board members, management companies, but residents. And we were able to find one of the top community association law firms in Houston with Lang and Associates. Let me welcome you to our expert, one of our favorites, Attorney Shannon Lang. Good morning, Shannon.
Hi, Steve. Good to be with you again.
It's good to see you. I got to tell you, what you do for associations is so important. People don't realize it's like running a major corporation. And there's so many aspects to it. And these associations really have to rely on you.
Yeah, I mean, we've got associations that operate on an annual budget of a few $1,000s and associations with annual budgets in the millions. They are businesses, and no matter what, no matter how big or how small it is, they run off of the hard-earned dollars of their members. And we take that very seriously as we try to guide and help our clients.
Well, first of all, tell everybody how you started Lang and Associates.
Sure. I came out of the University of Virginia School of Law in 2007 and took a pretty traditional big law path. I worked for a federal judge for a year, then worked for an international law firm doing corporate defense work for huge Fortune 100 clients. But after a while, I wanted to do something a little more personal and direct. And I started my own firm about 11 years ago. I got into community association law kind of by accident. I had a colleague that did it. And over time, it's just grown organically. We now represent dozens and dozens, hundreds of community associations throughout Texas, primarily in the greater Houston area, and continue to focus on this while at the same time maintaining some commercial litigation work, which means we actually get into court, we argue motions, we try cases, we get in front of juries, which is really invaluable when we're dealing with HOAs, because so many of them have issues that go far and beyond just collecting assessments and enforcing deed restrictions.
Shannon, I got to tell you, I haven't shared this with you yet. We get so many letters with all the shows that we do. Usually we get questions to ask the experts. What we get, though, with your show is people just thanking us for having a show like this. And they're surprised that no one else did it in Houston. And I just had to bring that out because there's and I don't know if they're board members. Once in a while, they'll say if they're a board member or not. But people just thanking us for this show. And we're just so proud that we've got such a great firm like yours, Shannon. So let's get to our questions. The 25 minutes goes by so fast. My first question is, what can association charge a person if they do not pay their assessments?
We're getting this question a lot right now. For most folks who pay annual assessments, they came due on January 31st, and they're going to start getting notices if they haven't already. HOAs in Texas have a lot of power. They're mini governments when you really think about it. And while the legislature, I think, is fairly exacting in requiring HOAs to operate somewhat professionally, they still do have a lot of power and authority to operate their business and to avoid having to force the cost of non-payment onto the other members. And so if you fail to pay your assessments, you can face some pretty steep penalties. HOAs can generally charge a late fee, interest as much as 18% per year. And if you don't respond to your management company or your board when they tell you you're late and your account gets referred to a law firm, you could find your costs skyrocket quickly. You will be charged all costs of enforcement. Those are everything is as little as a stamp to send you a letter, or hundreds of dollars an hour for a lawyer to address your account. In Texas, the associations are required to provide you at least a notice of delinquency in 45 days to pay before they start passing on those costs of collection and enforcement. So we strongly encourage owners to take advantage of that. Owners in Texas are entitled to a payment plan of at least 3 months, and depending on the policy of your HOA, up to 18 months or more. And so if you find yourself in financial straits and you need help, we strongly encourage all owners, and this is against my own interest, because if you pay your assessments, I have less work, but we strongly encourage folks to take advantage of that 45-day payment period and the opportunity to enter into a payment plan to avoid getting sent to a lawyer and finding what might be a $400 assessment blow up to a $4,000 problem. And that happens really quickly.
Shannon, if they owe money on their assessments, can they still run for the board?
In Texas, you can. You might see in your governing documents language that says that anyone who's delinquent cannot run. That's been superseded by statute. So even if it's in your documents, it's really hard to amend the documents a lot of times. It's just considered a nullity. You can run for the board. But you can't run for the board for the sole purpose of dictating whether and to what extent the association pursues you. As a board member, your obligations run to the association. And if you have a conflict of interest, which you would have if you are in enforcement and on the board, then you should be excluded from all discussions and all decisions about what to do with your account. And that's an interesting question because we are seeing this a lot. In fact, we just terminated a client because members who were suing the association for, frankly, some fairly frivolous things managed to get themselves on the board and believed that once they were on the board, they could vote to pay each other and pay themselves with association dollars to resolve their own lawsuits. And we told them that was absolutely inappropriate. You can't do that. You have to exercise fiduciary duties to the entity. And when those became intractable problems, we withdrew. We can't work for people that are acting out of self-interest instead of in the best interest of the association.
I'm curious. Here in Florida, I don't know if it's trickled down to Texas, but a community association just filed bankruptcy, and it turned out they didn't even have an attorney representing them. Does that surprise you?
That does surprise me. Here in Texas, you do have to be represented by an attorney, except if you are litigating a case in small claims court. Here it's called justice court, JP court. The JP courts don't require corporations to be represented, but even if that's the case, we strongly encourage all HOAs to be represented, because if you're a board member and you're not an attorney and you decide, well, I can handle this, and it goes poorly, then you're on the hook. You can be on the hook. Why would anybody want to be on the board and have personal exposure? So we always tell our boards, don't invite exposure. Take advantage of your service providers. But to declare bankruptcy without a lawyer is pretty unheard of. I don't know how that could happen. I would imagine somebody would object and something would happen as a result. And filing bankruptcy is very complicated, especially for an HOA. So we need a lawyer.
We hear how assessments are going up a lot. First of all, what is causing it? Is that legal?
Yeah, assessments are going up, and we get a lot of calls from homeowners who want to sue their HOA because their assessments have gone up. And there's very few avenues for that. The first place to look will be in your governing documents. In many communities, there's a limit to how much a board can unilaterally increase assessments. It might be 10 or 20% a year. And beyond that, there might be a requirement to have a vote. But the reality is that everything's getting more expensive. For condominiums, the primary driver of increases in assessments, especially some fairly significant ones in recent years, has been insurance. The Gulf Coast has suffered some major impacts for insurance markets, as Florida has seen, and premiums for condominiums have skyrocketed. That's less of an issue in subdivisions, but the issue that extends across all of our communities is that, and under the current economic environment, the cost of goods and services have all gone up. Import taxes are impacting the construction industry, and the general cost of living is impacting the cost of finding service providers. And all of that trickles down to your assessments. Because what an association needs to be doing, in addition to enforcement, is landscaping or fixing the gates or, repairing a trash bin enclosure or, what have you. And if a 2x4 has increased in cost by 50 or 100% in the last few years, someone has to pay for that.
What about someone who doesn't agree with the HOA rules? What can they do?
Well, it depends on what the disagreement is. By no means are boards perfect. We find all kinds of boards that behave badly or just out of a lack of understanding of what they need to do. Typically we recommend in the first instance that you get involved, go to board meetings, ask questions, and importantly, I say this knowing that a lot of board members are not pleasant, but do it pleasantly because you do catch more flies with honey. And that's especially true when you deal with managers, because managers in a lot of our communities, and a lot of the town here, are managing a portfolio of communities. So one manager might have 8 or 12 communities that they're handling. And so if you call with a question and you're nice, you're much more likely to get attention than if you're unpleasant because they've got 700 more calls to take. But start with asking questions, read your documents, go to board meetings. I am constantly surprised at the calls we get from homeowners who are upset about something happening in the community. And we say, well, what are they telling you at the meetings? We say, well, I don't go to the meetings. Well, if you don't go to the meetings, then it's hard for us to help. But when that fails, there are lawyers out there who can help explain how to interpret the governing documents and what's allowed under Texas law. So, those are ways to go. Of course, lawyers cost money. And the other thing that we encourage everyone to do is if you don't like how your association is being run for the board. That's something I must say with every phone call I get from a homeowner. Have you tried to run for the board? Run for the board. And I would say 90% of the time, the response we get is, God, no, I don't want to be on the board. Well, then it's a little harder to complain if you don't want to be part of the solution. But the place to start is always the documents, your declaration, bylaws, and policies.
So we just got our first text in from Mike in Sugar Land. He wants to know, what are your thoughts if a board member is paid? Do you think you could get more qualified and people to be more active on the board? Your thoughts?
I personally think paying board members is a terrible idea. I think that the place to pay is your manager. Because really the day-to-day affairs of the association are handled by a manager. And the benefit of that is that your manager has contractual and statutory obligations and insurance. So when they make a mistake, you have somewhere to go. You have someone to sue. Paying board members, in my opinion, creates a lot of bad incentives. Mm-hmm. It's not necessarily that you're going to get better people on the board. It's very likely you're going to get unemployable people on your board because if they can't find a job and they see an opportunity to just get elected into one, you may well find that these aren't the people you want there, and that their motivations are not the ones you would want to see. It's not that they're acting in the best interest of the association. They really are acting in their own interests. And to that end, many governing documents flat prohibit payment to board members. And we strongly discourage it. In fact, under Texas law, if somebody wants to contract with a board member, they have to go through certain hoops to do so. So for example, if you've got a board member who runs a landscaping company and he wants to bid for the landscaping work in the community, the association is obligated to seek multiple competitive bids. The board member who's submitting a bid cannot see those bids, can't be a part of any decision-making about the bids, and has to submit his or her own independent bid without any knowledge of what else is going on. And then those decisions have to be made by a disinterested set of board members. So if we're that concerned, and if the legislature is that concerned about contracting with a professional, then you can imagine there's similar, if not more, concerns about turning your board members into paid employees. And the exposure to the association is really high. It's not worth it. It impacts your insurance too. I wouldn't do it.
Shannon, do you get very many questions about Airbnbs?
We get tons of questions about Airbnb.
Especially from people who bought their house and they wanted to use it for an Airbnb.
Oh, yeah.
Can an HOA stop them?
Absolutely. We get this question a lot. In newer communities, now that people are aware of this issue, the declarations are typically prohibiting it. But for folks who bought in thinking they could do this only to find out they can't, a couple of things. One, these are legal restrictions. We have people who call and say, I'm a property owner and I have property rights and I can do whatever I want with my property. Unfortunately, once you buy into a deed restricted community, that isn't really the case. The other question we get a lot is, I bought and I was doing Airbnb and now they've amended the deed restrictions and say I can't, and that's not fair. I should be grandfathered in. But that's not the case either. These questions have been presented to courts and have gone all the way up to the Texas Supreme Court. And in Texas, the associations can prohibit short-term rentals, and they can amend their documents to prohibit short-term rentals, even on people who were previously utilizing their properties as such. And particularly in some condominiums, depending on how the documents are written, the board can prohibit short-term rentals without commencing a vote of the entire association. So we generally tell folks, if you want to operate an Airbnb or a short-term rental, we strongly discourage anyone from doing that in a deed-restricted community, because you can never be sure that that ability will be protected going forward. Also, generally, people really hate it. And we recently, I testified as an expert witness in a trial over an Airbnb issue. And while juries don't tend to like HOAs, they come in kind of, on their back foot because juries don't like HOAs. They really hate Airbnbs. So it's tough if you're the person trying to say, hey, I want to be able to do this. And in fact, in the recent case I was working on, the jury had no problem saying that the HOA was well within its rights to prohibit a short-term rental use in a deed-restricted community. So don't do it. If you are doing it, I strongly encourage folks to be the best Airbnb host out there with respect to your neighbors, because once you're a target, once the neighbors are unhappy because there's parties or too much traffic or too much noise, it doesn't take a lot to get a community to rally behind Airbnb restrictions.
Yeah, we get a lot of, this is across the country, of the community, they say they have a lot of tenants and they're not respectful to community like owners would be. And they want to know, what can the HOA do to get rid of these type of tenants?
Mm-hmm. It's a tough question. Condos have different rights than subdivisions. In Texas, the HOAs, for a subdivision, don't have a lot of power to do much about tenants. They can't screen them. They can't require background checks. They can require the owners to provide contact information, the terms of a lease, and of course, owners are responsible for any deed restriction violations by their tenants. But one thing that associations can do, if they have the ability to get the votes, is establish rent caps. And we've seen that in some communities, and particularly in condos. where, for example, the deed restrictions are written to require that an owner live on site for a certain amount of time before it can become a rental, or that only X percentage of the lots in the community can be utilized as a rental. And if you want to rent, you have to be on a waiting list until an open spot arises. But for the most part, unless those things were written into your documents by the developer, that requires some real work by the members to establish that. Now, with respect to really bad tenants, and we've got these issues, we're dealing with one right now with a really bad tenant, the general deed restrictions are still there. If the tenant is letting their dogs run loose, creating noise violations, not maintaining the property, then the owner can be held liable for all of those violations. And we find that landlords tend not to like too many things that impact the profit that they're making on their rent. And so if the tenants are in enforcement, the owner's in enforcement because of bad behavior by their tenants, we often find that they will get evicted or they'll bring their behavior into compliance with the restrictions. But if you're concerned about that, and it's a big concern for condos, we really recommend that people ask a lot of questions before buying in. An issue that's unique with respect to rentals for condos is that once a condominium complex becomes two tenant occupied, you no longer qualify for Freddie Mae or Fannie Mae backed mortgages, which has a serious impact on the ability to sell. So condos do have more rights, but still not really, unless the documents provide it, a right to screen and refuse tenants. Condos can, whether they do is another issue. Whether they can do it in a way that doesn't trigger Fair Housing Act issues is another issue. But it's tough. It's tough with heavily tenant-occupied communities to try to get things back into more of an owner-occupied environment.
It's another text from Rick in Memorial. I just found your show last month. Thank you so much for such great information. I'm thinking about buying a townhouse. What rules will apply to me?
Yeah, we get this question all the time. So it depends. A townhouse is an architectural style. It's not a determination of whether you're in a subdivision or a condo. And a townhouse is typically, a 3 or 4 story, narrow, long building on a fairly small lot. They may or may not be have shared walls. Typically, they're considered to have shared walls. Some are created as subdivisions where the owner is responsible for the entire structure from foundation to roof. Some are created as condominiums where the association is responsible for the exteriors and the owner owns from the finished surfaces in. You'll know by looking at the declaration. So, for example, I'm in a townhouse, but it's a subdivision, but we represent many townhouse communities that are condominiums. And what rules apply to you really depend on how it was structured. Like I said, you'll know this by looking at your declaration. You can also tell by looking at your deed. If you own a condo, your deed will say something like Unit 5 of the Memorial condominiums and a 0.005% undivided interest in the common elements. Because if you're in a condo, you own the interior surfaces in and an undivided percentage of everything else in the condominium. Everybody owns the roof, the foundations, the exterior surfaces, the landscaping, the common areas. And so that's how you kind of know you're in a condominium. That's the fundamental concept of a condominium, is the shared ownership of the common elements.
Hey, moving into an association is a whole different world. And that's why we have a show like this, to educate you. There is so much when it comes to an association. We're so lucky to have you, Shannon. Tell people how they can reach you.
Sure. We're online at www.shannonlanglaw.com. That's Lang. And there's a contact us. Actually, we had to take down the contact us link because it was getting spammed with lots of porn. But our phone number is there. So you can always call us, 832-479-9400. We take pride in answering the phone. There's no phone tree. There's no press 1 for this or press 2 for that. We will answer the phone. If we don't, it's because every person in the office is on the phone, in which case you'll get our voicemail. We'll call you back within a business day. And we welcome calls from board members, owners. We can't always help, but we can direct you to someone who can. If we have a conflict, or we just can't take your case. Or for a lot of homeowners, they call and they want help, but we tell them, like, a lawyer's going to cost more than you'll ever save. So again, working against my own interests, you might just want to work with your HOA. But we welcome calls and emails from anybody.
We're so lucky to have you. Shannon will be back again with us next month. Shannon, thank you so much. Have a wonderful rest of the week. We'll see you soon.
Thanks, Steve.
That's Shannon Lang & Associates in Houston, Texas. That's going to do it for us today. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.